Before we move on, let us be reminded of what this is truly about. This is not about labeling Carlos Smith as a criminal or accusing him of a specific offense. He has not been charged with a crime in connection to this incident, and like everyone in our justice system, he is presumed innocent. Our goal here is not to prosecute from a keyboard, but to look at the unsealed court records, the witness statements, and the investigative theories that the state is currently weighing. We are analyzing the accountability theory as a legal concept to understand why the community is asking so many technical questions. We are here for the facts, the forensics, and the pursuit of the truth, wherever it leads. The legal architecture of the Romeca Meeks-Blackmon case is currently shifting under the weight of a mounting forensic reality that is leaving the defense with fewer places to hide. As we move closer to the pivotal May 6, 2026, hearing at the George N. Leeton Criminal Court building, a haunting question is beginning to dominate the legal corridors. With the self-defense narrative slowly collapsing under a mountain of secondary surveillance and digital footprints, is Quadajah, Holly, Johnson finally going to speak on the true intent behind those 3 shots? If you are ready to see how the system is finally boxing in the truth through the unyielding power of accountability theory, make sure you like this video and subscribe right now. We are tracking the exact moment the legal paper shield officially shatters. We are breaking down the reported forensic stalemate that the defense is currently facing. For months, the primary pillar of Holly Johnson's defense, led by attorney Ari Williams, was the existence of stalking no-contact orders from 2025. But here is the factual pivot. It has now been entered into the record that those orders were reportedly never legally served to Romeca Meeks-Blackmon, making them virtually irrelevant to a self-defense claim. When your fear is based on a document the other party claimed never knew existed, the law begins to look at your intent through a much darker lens. We have to ask, if the paper shield was never about protection, what was it about? Was it actually about alleged preparing a preemptive alibi for a planned confrontation? If you believe the truth is finally coming to light, hit that subscribe button right now. In accordance with these, the alleged digital execution revealed through the McCormick Place high-definition grid. Sources close to the investigation suggest that the alleged 27-minute lying-in-wait period, which was once just a GPS data point, is now a high-definition visual record. This footage reportedly shows a level of stationary intent that is almost impossible to explain away as a chance encounter or a simple car change errand. When the evidence from the geo-fencing to the acoustic shot synchronization consistently points toward a tactical interception, the defendant is faced with a chilling choice: maintain a failing defense or finally address the coordination that occurred on that sidewalk. Every like on this video is a demand for the full unmasking of the ghost data that could prove who was truly leading the charge that morning. But the most significant pressure point is the silence of Carlos Smith. The accountability theory is a two-edged sword. As witnesses continue to testify about a physical headlock and a celebratory fist bump, the legal circle is closing not just on the shooter, but on everyone who was present. If the evidence continues to favor the prosecution's theory of an ambush, the incentive for the defendant to disclose the true intent increases as a matter of legal survival. Was this a personal dispute that spiraled out of control, or was it a coordinated attempt to permanently remove a financial and emotional obstacle, as some investigators have theorized? If you believe that the peacemaker narrative is the next to fall, go ahead and hit that subscribe button and join our call for total transparency before the May 6th gavel falls. The weight of this case is forcing a level of scrutiny that technicalities can no longer ignore. The Illinois Appellate Court may have remanded the case for a detention review, but the lower court must now weigh that procedural right against the documented forensic fact that an unarmed mother was silenced in a school sanctuary. This is the day of reckoning, where intent meets evidence. We are standing with a community that is tired of loopholes and ready for a confession of the truth. If the evidence proves the self-defense claim was staged, Should the court immediately upgrade the charges to premeditated murder on May 6th? Share your legal theories in the comments below. The strategic walls are closing in because the accountability theory doesn't just look at the hand that pulled the trigger. It looks at the mind that coordinated the movement. If the legal defense continues to fray under the pressure of the McCormick Place surveillance and the forensic timeline, the defendant is forced to confront the alleged mission signal that witnesses have already put on the record. We are talking about the alleged fist bump, a gesture that, in the eyes of a jury, could convert a claim of fear into a documented act of intent. If the evidence shows that the 3 shots were fired while the victim was being physically restrained, then the narrative of a spontaneous fight is legally dead. The court must now ask if the defendant will continue to cling to a self-defense plea that is being systematically dismantled by high-definition optics and synchronized acoustics, or if the May 6th hearing will be the moment the true intent of that 27-minute wait is finally addressed. Is the stalking no-contact orders technically collapsing? As a defensive strategy, if the prosecution successfully argues that these filings were never intended to keep Romeca Meeks-Blackmon away, but were instead created as a legal insurance policy for a future crime, then the procedural error narrative mentioned by the appellate court becomes irrelevant to the question of guilt. The court is being asked to consider if a defendant who allegedly used the judicial system to stage an alibi can be trusted on an ankle monitor. If the digital ghost data shows that the defendants were discussing the self-defense narrative days before the confrontation even happened, then the true intent is no longer a mystery, it's a confession written in metadata. If you believe that the law should be a shield for the innocent and not a cloak for the calculated, go ahead and hit that subscribe button right now. We are standing with a family that wants the world to know that Romeca didn't just show up to a fight. The state is preparing to argue that you cannot have a fear-based shooting when the victim is already being physically dominated and restrained by a secondary party. This is the ultimate checkmate for the defense. If Romeca was already pinned down by Carlos Smith, then the imminent threat required for a self-defense acquittal was factually non-existent. The judge on May 6th will have to weigh this physical reality against the appellate court's procedural remand. We are the watchdog for the truth, and every like helps us keep Romeca's name at the top of the search results, while the forensic lab finishes the high-stakes DNA testing for the June deadline. Thank you for your incredible support as we peel back the final layers of this South Loop investigation. Now subscribe and let's make sure the true intent is the only thing trending when the gavel finally drops. If the surveillance proves Romeca was restrained during the shooting, should Carlos Smith be arrested for accountability before Mother's Day? Share your thoughts in the comments and let's get the truth trending. In any self-defense claim, the law asks if the defendant had a clear path to de-escalate or leave the area. If the McCormick Place grid shows the alleged suspect's vehicle was functional and the exit route was clear, yet the defendant chose to exit that vehicle and engage an unarmed woman, the true intent shifts from protection to aggression. We are looking at the potential unsealing of the pre-incident cellular pings, which could show that the parties involved were tracking Romeca's son's school registration documents to find her exact drop-off time. If the intent was to find her at her most vulnerable moment, while her child was present, then the paper shield of protective orders is legally viewed as a weapon of entrapment. Reports indicate that in the minutes following the 3 shots, there was no call to emergency services from the suspects, no attempt to render aid, and no report of an emergency, self-defense situation to the local precinct. Instead, the digital trail shows a deliberate movement away from the South Loop and toward a secondary location. Under Illinois law, flight from the scene can be used as factual evidence of a consciousness of guilt. The judge on May 6th has to ask, if you were a fearful mother protecting your unborn child, why was your first instinct a celebratory fist bump and a high-speed departure instead of seeking the protection of the police? This behavioral gap is the smoking gun that the prosecution is using to push back against the appellate court's request for leniency. If you stand for a justice system that values actions over excuses, hit that subscribe button right now and join our advocacy for the truth. As the forensic lab nears the completion of the gunshot residue distribution report, we may finally see the physical proof of how close the weapon was to Romeca's face. If the residue proves a contact-range execution while she was restrained in that headlock, then the true intent is no longer a matter of debate. It is a matter of record. Thank you for your incredible loyalty as we hold the system's feet to the fire. Now subscribe and let's make sure Romeca's justice is the only thing trending when the gavel drops on May 6th. If the flight from the scene proves a consciousness of guilt, should the appellate court's remand for release be officially denied on May 6th? Share your thoughts in the comments and let's get the truth trending.